Hello, my name is Anthony Gair. I'm a partner in the New York City law firm of Gair, Conason, Steigman, Mackloff, Bloom, and Rabinowitz. I've been at the firm for over 30 years. Our practice concentrates on the handling of catastrophic injuries, and we solely represent plaintiffs in such cases. Today I'm going to be discussing with you the law of construction site accidents, and specifically Section 240 of the New York State Labor Law. The reason I'm going to concentrate on Section 240 is that's where all the action is these days, and that's where all of the new changes are occurring, and it's the most important section of the labor law. Those of you who practice in this area are familiar with Section 241(6) of the labor law, and we know basically that under 241(6) you need to have a violation of a section of the New York State Industrial Code, which, for those of you who don't know, has not been amended since 1972. An important distinction with regards to 241(6) and 240 is that 241(6), as you may know, applies to only construction, renovation, and demolition projects, while Section 240 applies to painting, altering, cleaning, etc., construction, everything that's stated in the statute. As for Section 200, Section 200 is nothing more than a codification of the common law, and it codifies the duty of an owner and the general contractor to provide a plaintiff with a safe place to work. So I'm not going to be discussing that because the law hasn't changed that much over the years. Section 240, and for those of us who do this on a regular basis, we can all agree is constantly changing. It's like a pendulum. It goes back and forth. At one point it's favoring plaintiffs, at another defendants. If you look at the history of the cases, and in the submission that you have access to, there's a history of the law given, because in the context of Section 240, it's very important to know the history, because at the present time, we're really back to where the law was in almost 1985. Let me just talk to you a little bit about this, what I say this pendulum is. From the late 70s, really 1978, when a case by the name of Hames versus New York Telephone Company was decided, and it's in the submission, until the mid-90s, the law clearly favored the plaintiffs. Then in the mid to late 90s, the pendulum began to swing and more towards the defendants, and it's no different than the Supreme Court of the United States in the area of criminal procedure, where you see, based upon who's the court, this swinging, especially in the area of criminals' rights, from Miranda and Escobedo, which used to be able to beat the crap out of a suspect. Then we had Miranda, Escobedo, and now with the present court, and over the last 10 years, we've seen an erosion of those cases. Same thing with the labor law. So in the late 90s to the early 2000s, especially, and I'll talk about them as we go on. In 2003, we had the Court of Appeals decision in Blake versus Neighborhood Housing Services, which introduced, there was one case prior, but it introduced the concept of sole proximate cause. In other words, a plaintiff's culpable conduct, a plaintiff's negligence, as we know, is not a defense to an action predicated upon Section 240 of the labor law. But through some very ingenious defendants' lawyers, what became introduced and what became the law in Blake was this concept of the sole proximate cause, so that if you could show that a plaintiff's actions were almost like an intervening cause. Those of you who know about the superseding intervening cause defense, which the leading case in New York remains Cush versus City of Buffalo. The plaintiff's actions so attenuated any actions by the owner or general contractor that the plaintiff could be held to be the sole proximate cause of the accident. As plaintiffs' lawyers, it would be nice, or as plaintiffs or defendants' lawyers, it would be nice for us to know exactly what the law is under Section 240. Unfortunately, as I said, these cases go back and forth, and historically, Section 240 cases have been very fact-specific. I'm not going to go over every case during the last year. You can read them. Most of them are in the submission. What I want to talk to you about, and what is crucial for you to understand, is the concepts underlying Section 240. And since 2009, up until the present, the decisions, because of the makeup of the court, since Judge Lippman has become chief judge, have been fairly consistent. Now, the most important case, the case that changed everything, and it's certainly the most important case in the last 10 years, is Runner versus New York Stock Exchange. It's a Court of Appeals decision. Many of you may know it. It was decided on December 17th of 2009, and I think it's at page 62 of the submissions, but it's in the submissions. Think about this. It was decided merely 3 years ago. It's been cited well over 100 times. And I want to really get into the facts of Runner because it's very important for you to understand the concept that was enunciated in Runner because, as I said, it changed everything. In Runner, the plaintiff and his co-workers had to move a large reel of wire weighing 800 pounds down a set of stairs. And you have to understand this. The stairs are over here, and assume I'm the 800-pound reel of wire. They have to get it down the stairs. How do they do that? The plaintiff and his two co-workers are told to tie a 10-foot rope to the reel. And which they did. They tied the rope to the reel, and then they put a metal brace in a door frame and took the rope, put it around the brace, sort of like a makeshift come-along, and these three workers are holding it, and they're serving as counterweights. Many of you have seen counterweights as you walk around the city on the back of these mobile boom cranes. They stop the crane, prevent the crane from tipping over. So the theory was that if they put this rope around the bar and then they have it on the reel, they're going to be able to hold it. Well, it's almost like a Three Stooges movie, if you think about it. They do that, and the reel is here. One worker starts to push it down, and you can imagine what happens. The plaintiff and his co-workers are holding this loose end of the rope, and as this reel, it's 800 pounds, starts to go down the stairs, they're pulled. And the plaintiff's hands are smashed into this metal brace. This case was tried to a verdict in federal court, and it resulted in a verdict for the defendants. The trial judge at the trial court level in federal court threw out the verdict and directed a verdict for the plaintiff, and it was appealed to the Second Circuit Court of Appeals, which certified it to the New York State Court of Appeals. And this is a crucial statement in Runner. And it's crucial that you understand it, because after Runner, many courts and commentators really didn't understand what was going on in Runner. Let me explain to you. The crucial statement in the case is this: the single decisive question is whether plaintiff's injuries were the direct consequence of a failure to provide adequate protection against a risk arising from an elevated differential. Well, what's the elevated differential? The plaintiff didn't fall. Section 240 is known as a scaffolding law. Why? Because when it was first enacted back in 1912 under the original labor law, it was to protect workers working at great heights. A lot of big buildings were going up in the city at the time. And it was to protect those workers from collapsing scaffolds at 30, 40, 50, 100 feet where the scaffold might collapse and they fell. Or an object, a beam, fell a number of feet from a building and struck a worker on the ground below. Here, you don't have a worker falling at all. The worker, in fact, starts out at the same level as the reel. It's the reel that fell. And when Lippman in his decision says the single decisive question is whether the injuries were a direct consequence of a failure to protect against a risk arising from an elevated differential, the differential was the reel that fell. The plaintiff never fell. And what people didn't understand for a while, and courts were getting a little confused, was the following statement in Runner. Because the court went on, Judge Lippman, who wrote the decision, went on to say, the relevant inquiry is whether the harm flows directly from the application of the force of gravity to the object. You have to put that language into context because you had courts after Runner focusing on that and not focusing on, and not understanding that you still needed, or as a plaintiff, you still need to make out a 240 case in elevation-related differential. Maybe not as great a differential as in the past, and we'll get to that, but certainly you still need that. So this gravity language was put into the context of the facts of Runner. And the language comes directly from two cases. One is Ross versus Curtis Palmer, which was decided by the Court of Appeals in 1993. It's cited in the materials within the Runner decision. And in Ross, some of you may remember, this worker is way up on a building on a scaffold, and he has to bend over because of the way the scaffold is positioned. And as a result of bending over, he never falls. But as a result of bending over, he injures his back. And then with that context, the gravity language was used, and the court dismissed his case, and rightly so, because although he was working at an elevation, there was no force of gravity applied to his body, either by being hit by an object or falling. The other case that was cited for this language in Runner, and Lippman took it right out of these cases, is Rokovich versus Con Edison Company, which they decided in 1991. Those of you who've been around for a while may remember it. It was a case that concerned us as plaintiffs at the time. But in Rokovich, a worker is working way up at the top level of a building undergoing construction, and there's a pit, a trench with hot tar in it, and he steps into the plaintiff does, steps into the trench and sustains very, very serious burns. And that case was also dismissed because although he was working at an elevation, the elevation was not didn't cause his accident. There was no force of gravity on him. So that is the reason that language was cited in Runner. So I just want you to all remember, although it may not have to be as much, could be a foot only, you still need, and the first inquiry is there an elevated related differential. Now, the most important case of the last year, without a doubt, it was decided on October 25th of 2011, is Walensky versus 334 East 92nd Housing Development Fund Corporation.